Okay, hello, good evening. For those of you that are in Minnesota, I hope all is good and you're enjoying that wonderful snow. I know I always enjoy the snow when it's so beautiful like that. That's just me. So welcome everyone. My name is Carla Zevnik-Seifzer. As many of you know, I'm an advisor as well as the president of ClearStep Financial. We ask everyone to mute themselves in the computer. We'll have questions at the end that you can unmute yourself, but please mute and then also stop your video. Just on the bottom, just click and stop your video. So we thank you for that. And tonight's presentation is estate planning. ClearStep Financial is here to help educate and guide our clients through our ever-changing financial world. And to help us with this goal tonight, we have Stacy Vogeltanz. She's an attorney here in the Milwaukee area. We've used Stacy for many years. For those of you that are in other states, Minnesota and other states, please make sure you contact your advisor for a referral for an attorney in that local area. I believe you will find Stacy's presentation educational, informative, and enlightening. And with that, we welcome Stacy. Thank you, Stacy, for being with us tonight.
Thank you so much, Carla. I appreciate the opportunity to educate your clients. So to start with, I'm just going to share my screen. I do have a PowerPoint presentation. So Carla, can you just confirm that you can see that? And it should be a PowerPoint now. Okay.
Yes, we can see it. Thank you, Stacy. And then would you like questions throughout? I'll look at the chat. Or would you like at the very end, do you want people to have questions?
If you keep an eye on the chat for me, feel free to interrupt me with questions if they're on topic. Otherwise, I will just go through the whole presentation, and then if people want to ask questions at the end, I'll be sure to stick around for as long as we have questions. But Carla, you can interrupt me with them if they come up, okay?
Thank you. Yes.
All right. So let me just see if I can close my video. There we go. All right. So as Carla mentioned, my name is Stacy Vogeltanz. I am an attorney with Angermeier Rogers law firm. We are an estate planning and elder law firm. That is what we really do. We don't dabble in other things. We try and become experts in what we know. So that's what I am talking about today. So to start with, let me just explain to you what an estate is. And the reason I start with this is because a lot of times people will say to me, oh, I don't really have an estate. I don't need an estate plan. I don't have that much. I don't have that much money. And that's not what an estate means. It doesn't mean a certain dollar amount or, wealth passed on from generation to generation. If you own anything at all, you have an estate. An estate just means what you own. So it could be as simple as just a checking account at the bank. It could be your house in a checking account. It could be, much bigger than that. You've got a lot of accounts with ClearStep. You've got IRAs, life insurance, annuities. You've got your house and your vacation home, 529 accounts for the kids. So whatever you have, your assets are just what your estate is. And so then as far as why we would do estate planning really tackles two issues. What most people think of as estate planning is saying where things are going to go after you pass away. So I know that I want my kids to inherit, or I know I want to give something to charity and something to my kids. That's part of estate planning. And the documents we use to transfer assets after you pass away are usually a will or a trust. I'm also going to talk about some other documents that we can use to transfer assets. But I also like to remind people that planning for your estate also includes planning for your incapacity. So people don't always think about that. But planning for your incapacity is just as important because you need to know who can control your assets, who can maintain your accounts, who can make financial decisions for you if you become incapacitated. And by that, I mean you're alive but not well. You're either physically or mentally incapacitated because of a car accident, just due to old age. It could be any number of reasons, but you do want to make sure that you have incapacity documents in place as well. So as far as who needs an estate plan, it's really everyone over the age of 18. So again, some people think, I don't have that much, I don't need an estate plan. That's not really how it works. If you have any assets, or even if you don't have assets and you just have debt, a college student who's 19 years old and is in college debt and doesn't really have a positive net worth, they're still going to need an estate plan. The difference is how complicated that estate plan is. So for that college student, they can probably get by with a very bare bones, a couple power of attorneys that say who can manage things for them if they become incapacitated. As you go through life, you're probably going to need to expand on that estate plan. So once you start having kids, you're probably going to want a will, because a will is where you name guardians for your children. As you go a little further in life and you start building wealth, you might want even more estate planning documents. So this is when people might start looking at trusts to protect their assets, to protect the inheritance that they're giving to the next generation. So these are all estate plans. They're just different versions of an estate plan. So as far as some common estate planning goal, I'm just going to read through these. So why do people plan for their estate, and what do they want to accomplish by planning for their estate? So the first one
not
says,
listening. What? Yeah.
The first one says, I want to control my property while I'm alive and well. So that one's pretty straightforward, right? We don't want to give up any authority. We don't want to give up any control of our property before we're ready to. Number two says, I want to take care of myself and my loved ones if I become incapacitated, retaining the most control I can. So again, we want to make sure that we're not going above and beyond what we have to. We want to have estate planning documents in place in case something happens, but we don't want to give everything away. Number three says, I want to give what I have to whom I want, the way I want, and when I want. So most people have a pretty good idea of where they want things to go. So commonly that might be to the kids, to the grandkids, to your church or your charity, but people might not realize that they have some options about how they do that and when they do that. So a good estate plan will give you that opportunity to say how you want it to go. So for example, I want it to go to my grandkids, but I just want it to go to them to pay for college. Or maybe, I want it to go to my grandkids, but I want them to go through school first, and then we will pay off their student loans so that they don't slack in school. So those are just some examples of how you might say how you want that inheritance to go to someone. Number four says, I want to maintain my privacy and avoid court control of my affairs. So the big one here is probate court. Probate court is the part of the court where the judge or the court will get involved if you don't have proper estate planning documents. So we'll talk a little bit more about that. And then the last one says, I want to save every tax dollar, professional fee, and court cost possible. So I think for a lot of people, this is a really important one because they're afraid to plan because they don't know how much it's going to cost, or they think it's going to cost too much, or they talk to a lawyer and it does cost too much. But what I want everyone to keep in mind as I'm talking through for the rest of this presentation is when you pay for your estate plan, you're actually paying for it twice. You're paying for it the first time when you actually set up the documents, and then you're paying for it a second time when it actually gets used. So when you become incapacitated or you pass away. So there are kind of two times when that cost comes into play. And I'll talk about that as I give this presentation. As far as when you should plan for your estate, basically anyone over the age of 18 does need an estate plan of some sort. Again, it's going to look different for everyone, but if you're over age 18, you no longer have a legal guardian who can make decisions for you, and that's why you need some sort of an estate plan. And the other important thing to know is that you need to do your estate plan before you need it. So I know it's not a fun topic. A lot of people don't want to think about it. They put it off because, you're young and you don't need it yet. But the worst thing that can happen is you put it off until it's too late. There are no second chances. If you become incapacitated, that's too late. If you pass away, that's too late. I can't tell you the number of calls I get from an adult child who says, you know, mom has been slipping for a while now, and doctors have said it's not safe for her to live at home anymore. She's moving into memory care tomorrow. We need a power of attorney for her. At that point, it's probably too late. If she's already incapacitated, it's going to be really hard for her to sign those legal documents. So you really do need to plan ahead before you need the documents. All right, so the rest of the presentation is really just going to be talking about a common estate planning techniques. So everybody probably has some estate planning techniques in place already, whether or not you knew they were estate planning techniques. Some of you might have more formal ones, and some of you might have ones that are created more or less by default. So what I'm going to do is I'm going to go through kind of each of these estate planning techniques and explain the pros and cons of each of them. And we're going to start with wills. So most people have heard of a will. They might not know exactly what it does, but what a will does is it tells the probate court judge where you want things to go after you pass away. So a couple important things here. If you have a will, that means that you are going through probate. If you've ever been told you want to avoid probate, a will does not avoid probate. A will requires probate. Another important thing to know about the will is it only works after you pass away. So while you're alive, if you're incapacitated, your will doesn't do anything to help with that. And the purpose of the will and the probate court is the way that we change ownership of your assets. Now, only certain assets are going to go through probate, and the assets that go through probate are things that you own in your own name, nobody else's name on it, and no beneficiary designation on it. So if I own my house and it's just in my name, that asset is going to go through probate. But if I own a bank account and my husband's name is on the bank account with me, that asset is not going to go through probate. That's going to go under joint ownership. If I have an IRA and I have a beneficiary on the IRA, that doesn't go through probate either. It goes to the beneficiary, as the beneficiary form says. And then lastly, if I own something in a trust, that is not going to go through probate. It instead goes under the rules laid out in the trust that I've created. So again, we only have to go through probate for things that are owned just in your own name with no joint owner, no beneficiary on that. And probate is just, again, it's the legal process that changes ownership. So the only way to get something from my name into my beneficiary's name, if there is no beneficiary form on it, the way to do that is to go through probate. As far as the cost of probate, this is one of the downsides of probate. So a lot of people come to me and they say, you know, I've been told I want to avoid probate, or my neighbor said, don't ever go through probate, it's terrible, but they might not know why that is. So a big downside of probate is the cost. National average is somewhere around 7.5% to go through probate. And what that fee is made up of is court costs. So there are filing fees. There are fees regarding publishing things in the newspaper. So that's something that you have to do in every probate. There are fees regarding taxes. There are fees regarding hiring attorneys. And so that's where that 7.5% is made up. If you're one of our listeners tonight from Wisconsin, you're going to do a little bit better than that. You're probably only looking at about 4% of the total estate in probate costs. Now, this is probably the most expensive, I will say, this is the most expensive this is the most expensive estate planning technique when it comes to implementing your estate plan. So again, remember, there are 2 times that you pay for an estate plan: when you actually set it up and then when you implement it. So if you have a will, it might not be very expensive to set up that will, but it's going to end up costing a bit more on the back end to administer that will. Now let's compare that to something like a beneficiary form. Doesn't cost you anything to set up a beneficiary form. Your advisor at ClearStep does that, and they review them with you all the time. And it also doesn't cost anything to administer that beneficiary form after somebody passes away. So usually it's just a form that you have to fill out, and you provide a death certificate, and that can change the ownership of the account. So probate is definitely on the most expensive side. Probate, another downside is it takes a long time, or it can take a long time. So average probate in my area is about 9 months to 2 years to get it done. And I would say that's actually probably closer to 18 months to 2 years to get it finalized. And the reason it takes so long is because it's a court process. So you're on the judge's timeline, you're on the court's timeline. So it just takes a really long time to get things wrapped up. You sometimes have to, I'm sorry, whoever's talking in the background, can you please mute yourself?
Yeah. And she was just like, well, you took me.
Gail on their laptop, can you please mute yourself? Thank you.
Oh, sorry.
Thank you. So the probate can take up to 2 years. And again, that's going to be the longest of all of the estate planning techniques we're going to talk about. There are much quicker ways. So for example, we'll use a beneficiary form again as an example. That's probably a matter of a few weeks to a few months to get that paperwork filed, get the death certificate submitted, and then get that account paid out to the beneficiary. Something like a trust administration, where you've got a few more moving pieces, could take about 6 months to get that done. So every different estate planning technique is going to take a different amount of time, but probate is definitely on the longer side. And then the last big reason to avoid probate is that probate is a public court proceeding. So couple potential issues here. First of all, if you've got family members who are a little nosy, you've got neighbors who might be a little nosy. If you've decided not to leave things in a traditional way, maybe you're disinheriting one of your children, or you're leaving shares unequally to your children, and you don't want anyone to know that. A will and probate are not the best way to do that, because a will is a public court document. What that means is anybody who wanted to go down to the courthouse and see your will and see where you left things, they are allowed to do that. So that's probably not a huge concern for a lot of people, but it might be. Privacy is important. But another concern is, why would you go through a court process when you don't have to? So there's only one other estate planning technique I'm going to talk about here in a second that requires probate. All of the other ones, all 4 other processes, don't require probate, don't require the court process. So I don't know many people who are excited to go down to the courthouse, excited to appear in front of a judge. Most people would say, if there's a way I can avoid that, if there's a way I can have my family avoid that, let's avoid it. And so those are the 3 main reasons why people want to avoid probate. As far as incapacity planning, a will not do anything to help with incapacity. So a will does not come into effect. It does not do anything until after somebody has passed away. So if you name an executor in your will and then you become incapacitated, that executor of your will has no access to any of your accounts. They can't call up your bank. They can't call up ClearStep. They can't do anything with your accounts because the will doesn't come into play until after you pass away. If you become incapacitated and you don't have any incapacity documents in place, what ends up happening is something called a court guardianship. Court guardianships happen in probate court, and they have all of the same downsides of probate. It's a court process. It's a long court process. It's an expensive court process. So the really easy way to avoid guardianship is to do what's called a power of attorney. That is our main incapacity estate planning document. The power of attorney comes into play when you're alive but not well. You're either physically or mentally incapacitated, and you can't make your own financial decisions anymore. You can't physically write out a check. You can't physically get to the bank, or maybe your memory starts to go and you're not remembering to balance your checkbook, or you're forgetting to pay bills. That's when your power of attorney would come into play. And what you do with a power of attorney is you name somebody who can make those financial decisions for you if and when you become incapacitated. So if you have that financial power of attorney, that is going to keep you out of the courts while you're alive. It's going to avoid the guardianship. Okay, so now we're going to move on to our second estate planning technique. And this one is titled Doing Nothing. So even if you do nothing at all, you have no estate plan in place, the state was nice enough to create an estate plan for you. So basically, the state says where things go when you pass away. And for a lot of people, it makes sense. It'll say if you're married, it goes to your husband. If you're not married and you have kids, it'll go to your kids. No spouse, no kids, it'll go to your parents. It'll go to your brothers and sisters. You follow the family tree down, and we find the nearest relative that it can go to. So it's not a terrible solution to have the courts decide where things are going. It makes sense for a lot of people, but it still requires probate. So we still have all of those downsides of probate, and you're not making any decisions in the process. So you're not saying where things go. You're not saying who's in charge of administering your estate. The court, the judge is making all those decisions for you. It's also not going to help with incapacity. So if you do nothing, you're going to go through that court guardianship, that probate process. It's going to be expensive. We're going through probate, we're going through guardianship. And so those are the two most expensive estate planning techniques we can use when it comes to implementing them. Now, on the other hand, there is one positive of doing nothing, and that is that it is the cheapest plan to set up, because you don't have to pay an attorney to do anything for you. So it's not going to cost you anything to set up, but it is going to end up costing you a lot on the back end when you actually have to implement the plan. So again, remember, we always have to think about the fee twice. Now I'm going to move on to our third estate planning technique, which is joint ownership. This is a really common estate planning technique, and it's probably one that most of you are using, even if you didn't know you had an estate plan or you didn't know you were already using an estate plan. But again, remember that if you own something jointly, whether it's with a spouse or with an adult child, whoever it might be, if you own something jointly, when you pass away, the joint owner is automatically going to inherit that asset. Joint ownership is really easy when it comes to setting it up and administration. So to set it up, you just, you have a joint owner on the account, and that's how it's set up. And then once you pass away, it's pretty easy for your surviving joint owner to get that account into their name. So let's take, for example, a bank account. Husband and wife have a bank account together, and husband passes away. The wife goes into the bank with a copy of the death certificate, and they take the husband's name off. And it's really as easy as that. And nothing goes through probate. So if you want to avoid probate, joint ownership is a great way to avoid probate. Now, where we might have some problems is after that first spouse passes away. It can get a little iffy. So I've got a little example up on the screen. It says with our nice young couple there, the husband, Tom, passes away first and goes into the bank with the death certificate and gets all of the money in her own name. There's no probate for that. But now all of the money is just in Anne's name, right? Because she doesn't have a joint owner anymore. And so when she passes away, when the wife passes away, everything would have to go through probate to get to her children or her beneficiaries, because there is no joint owner on that. So it works really well at preventing probate at the first death, but not so well at the second death. And it also might raise some issues if there would be a remarriage. So our first husband, Tom, passed away, and now Anne remarries Dan. Okay, so this is a second marriage. And when they get remarried, they do what married couples do. They open a joint bank account, they buy a new house, and they put it in both names. And now Anne dies before Dan. Dan's going to have that really easy process where he goes down to the bank, he goes down to the county recorder's office with a death certificate, and he gets everything moved into his own name. Now, when the new husband, the second husband, passes away, everything goes under his estate plan. Now, does his estate plan include Tom and Ann's children? I don't know, maybe, maybe not. Maybe he has children from a first marriage as well, and he only wants to leave to his children. And that would leave these children disinherited, whether or not that was the intention. So it can get really complicated when we get into second marriages and blended family. Joint ownership is maybe not the right idea. Another time that joint ownership can get somewhat sticky is when we're talking about incapacity. So with some types of accounts, if you have a joint owner, incapacity is not going to be a problem. So a common example of this is a bank account. You're never going to have a bank that requires both the husband and the wife to sign the check on the front and the back. They'll always accept one signature. But if we get to selling the house, you will have to have both spouses sign the deed and the paperwork to sign over the house or sell the house. And so if the husband is incapacitated and the wife wants to sell the house, she's going to have to go through a court guardianship to be able to sell her own house because her husband isn't able to sign the paperwork. He's incapacitated. Another place where this could get a little bit complicated is when we add adult children on to help out managing the finances. So I see this a lot where, you know, the husband died and mom is getting a little bit older, and so she adds her son on to help her pay bills, balance the checkbook, those sorts of things. So when that happens, sometimes we run into problems because that adult son now is a joint owner. Any trouble that he gets into, mom's money is at risk. And what I mean by trouble is maybe he goes through a divorce, maybe he gets sued, maybe he has to file for bankruptcy. If his name is on that account, he owns half of it. And so he can lose mom's money in a divorce. He can lose mom's money in a bankruptcy. So those are some of the risks of having your adult children added on as a joint owner on your accounts. What might be a better way to do things instead of naming them as a joint owner would just be to name them on a power of attorney. They can still help with all those same things. They can help balance the checkbook. They can make sure all the bills are getting paid each month. They can help with all the paperwork for selling the house, but they're not actually an owner. They're just a power of attorney. So they can still help in the same way, but your assets aren't at risk because they don't own them. All right, I'm moving on now to the plan of giving assets away. This is an estate plan because you only have to worry about what's in your estate, right? So if you give everything away before you become incapacitated, or you give everything away before you pass away, then you don't have to worry about going through probate or joint owners because you don't have anything left in your name. Now, the most common place we see this, we see people wanting to give things away, is when I hear, I don't want the nursing home to get everything. I don't want the nursing home to take my house. I want to make sure it goes to my kids or my grandkids. And so I often hear people say, well, can't I just give it to my kids now? And so that is definitely an estate planning technique. And when we're talking about the nursing home and protecting things from the nursing home, what we're talking about is how are we going to pay for that if we need long-term care? So there's a couple different ways you might pay. You could pay out of pocket. You can pay with Medicaid, and that's the one we're going to talk about. That's the big one. Or you can pay with long-term care insurance. With long-term care insurance, that's a great option because it means that you can really go anywhere you want to. You're not going to be limited to facilities that take Medicaid payments. You're going to be able to go to anywhere, any facility that you want, because every facility is going to take long-term care insurance. It's basically like private insurance to pay for your stay at the assisted living or the nursing home. Now, if you're looking at your screen and you can see this, there's a little chart here that explains how people are paying. So the big blue chunk says Medicaid, and that's 51%. Most people are getting on that Medicaid program in order to cover their long-term care stays. Just a small portion, the dark red, is about 8%. That's the private insurance. About 20% are paying out of pocket, meaning they're writing out a check for $7,000, $8,000, $9,000 a month each month to pay the bills. So what people are concerned about is getting on Medicaid, because that's when you really want to be able to do that at some point, so that you're not using up all of your hard-earned money, that you can pass something to the kids as an inheritance. Unfortunately, Medicaid is considered a welfare program, so it's not available for everyone. You have to have pretty low assets in order to qualify for the program. So whether you're single or married, you can always have a prepaid funeral. You can have really small life insurance policies. You can have your house and your household goods. You can have your car. For a single person, you can only have $2,000 in countable assets. Countable assets mean everything in the bank, everything at ClearStep Financial, everything in your life insurance, your IRA, your annuities, all of that is a countable asset. For married couples, they let you keep somewhere between $50,000, and this number is a little bit old. I didn't update it for 2023. It's almost up to $150,000. So somewhere between $50,000 and $150,000 is what you can keep if you're married. And the way they calculate that is based on how much you start with before you go into a facility. So for most people, they're not going to qualify under the Medicaid limits because they have too much money. So then we talk about how you might qualify. So one way that we help people qualify is by using an irrevocable trust. Now, the sole purpose of this irrevocable trust is to protect assets so that if you go into a nursing home or an assisted living, you can qualify for Medicaid without having to spend the assets in the trust. And why might we use a trust instead of just giving things away? In the eyes of Medicaid, it's exactly the same. You give $100,000 to the trust, or you give $100,000 to your son. Medicaid looks at it the same. But with the trust, you get a little bit more control. So with a trust, you appoint what's called a trustee to manage the trust, and the trustee has to follow your wishes. If they don't follow your wishes, you fire your trustee and put somebody else in place who will. Another really good benefit of the trust is that you can undo the transfer if necessary. So right underneath there, it says that the transfers to a trust or to an individual are subject to a 5-year look back. What that means is if you're going on Medicaid, Medicaid looks to see if you've given anything away in the last 5 years. And if you have, you're going to be ineligible for Medicaid for some period of time. And so let's say you decided not to do the trust, you were just going to give $50,000 to your son and $50,000 to your daughter, because you felt like you were in a good spot and you had 5 years and you felt comfortable doing that. And your son invested all the money in the stock market, but he didn't make good investments, and now his $50,000 is down to $10,000. And your daughter decided she was going to take the most extravagant trip to Disney World with her whole family, and she spent the $50,000. And now next year you have a stroke and need to go into a nursing home, and you can't qualify for Medicaid because you gave away $100,000. So one option is to ask the kids to give that money back, but they've spent it, right? Half of it is lost in the stock market and half of it was spent on a vacation. So there's no way to get that money back. If instead you had taken that $100,000 and put it in the trust, it would be sitting in a safe account that your son and daughter would not have been able to spend. And so if you don't make it the 5 years, you can get that money back from the irrevocable trust. So even though it's irrevocable, there are lots of ways to undo it, get the money back, transfer the assets. It's still a pretty flexible trust, even though it's irrevocable. So as far as what you might put into this irrevocable trust to protect it, a really good thing to put into a trust is always real estate. So that might be your house, it might be a vacation home. So if we put those assets into an irrevocable trust, you don't see any difference in your day-to-day life. You still live in the house, you still pay the property taxes, the heat, electric, all of those sorts of things. There's really no difference. Life insurance is another good thing to put into an irrevocable trust. And the reason for that is that you're not using your life insurance, right? It's there for the death benefit. So by setting it aside in an irrevocable trust, you're just setting it aside as an inheritance for your children. Brokerage accounts or investments may or may not be a good idea. If you move money into a trust, you don't get to take it out. You don't get to use it. So if you move a brokerage account into a trust and now you want to take $10,000 out to put a new roof on the house, you can't do that. You can't take money out of the trust. Once you put something into the trust, it has to stay there. So we would never put everything you own into the trust. We can't protect 100% of your money, but depending on your assets, we might be able to protect a good amount of it. So again, just to kind of highlight the difference between using the trust versus giving things away. With the trust, you are allowed to maintain a little bit more control because you can change the trustees and the beneficiaries. The assets aren't at risk if the kids run into trouble. So again, they lose the money in the stock market, they get sued, they have to file for bankruptcy, anything like that, the money in the trust is protected. People often ask me about this one. If I put my house in the trust and then the house is just too much work for me to keep up and I want to move somewhere smaller, I want to move into an apartment, can I sell the house? And the answer is yes. The trust can sell the house. It's just that the money from the sale of the house needs to stay in the trust. So you can't take the money out once it's converted from house into money. The money still has to stay in. And then I also like to mention that life estates for gifting the house no longer work for Medicaid purposes. So back in the early 2010s, you could transfer your house to your kids, but keep a life estate. And you kind of got the best of both worlds. You got a tax break when you passed away. You got the house protected from Medicaid. You still got to live there and manage the house. The kids couldn't sell it from underneath you or anything like that. But Medicaid took away that rule in 2014. So now if you do a life estate to try and protect your house, it's not actually protected from Medicaid. Medicaid can still get at the house. So they just don't work anymore. And I like to mention that because people often say, you know, when I went through this with my mom, we just did a life estate. Or when my neighbor did this, they said they just did a life estate and it worked great. And it used to work, but it doesn't work anymore. So I have just a really simple example here of how this trust might work for someone. So let's say we have Mary and she's widowed and she is worried about having to go into the nursing home and the nursing home getting everything that she has. And so she wants to make sure she can leave an inheritance for her kids. She's got a pretty simple estate. She's got a house worth $300,000, investments worth $200,000, and an IRA worth $100,000. What Mary might want to do is take her house and her investments and put them in the irrevocable trust. She still has her $100,000 in her IRA plus all of her monthly income to live on. If Mary makes it 5 full years before applying for Medicaid, she's just protected $500,000. That $500,000 made up from the value of her house and the value of her investments, that money is going to go to her kids. It's never going to go to the nursing home. It's never going to go to Medicaid. It's protected. All right, I am moving on to plan number 5. Our 5th estate planning technique is beneficiary transfers. So this is probably another estate plan that a lot of you listening tonight already have. Beneficiaries are very common on IRAs, annuities, and life insurance. You can actually put in a beneficiary on everything in the state of Wisconsin. So you can put them on your bank accounts, you can put them on your stocks, you can put them on your house even. You can list a beneficiary on every type of account you have. And so this is great for avoiding probate. If you have a beneficiary, nothing goes through probate. What it's not good for is incapacity planning. So having a beneficiary listed is not going to do anything to help with incapacity. So let me give you an example. You have an IRA and you've named your son as the beneficiary on the IRA, and now you've become incapacitated and have to go into the nursing home, and your son needs to get money out of the IRA to pay the nursing home. He cannot do that as the beneficiary. He has no access to that money until after you pass away. So it goes back to, again, needing a power of attorney, naming somebody who has access to that money if you become incapacitated. So even if you're planning on doing everything by beneficiary transfers, you still need the power of attorney. And now we are to our very last estate planning technique, and this is a revocable living trust. So first, let me say that the revocable living trust is different than the irrevocable trust. The irrevocable trust is more restrictive, and it's used specifically to avoid the nursing home getting your assets. So that's why it has to be more restrictive. The revocable living trust is what I like to call a will replacement trust. It gets things to your beneficiaries without needing to use a will, without needing to go through probate. So let me just briefly explain the different actors in a trust. The first person is the person who creates the trust. This might be called a grantor, a settlor, or a trust maker. They're the ones who set up the trust and put their money into the trust. The next character is called a trustee. The trustee is the one who manages.
Is she 651?
Oh, sorry, someone's talking again in the background. If you can mute yourself. The trustee is the one who manages the assets that are put into the trust. So it is who can access that bank account now that the bank account is in the name of the trust. And when you create a trust, you are the grantor, you are also going to be the trustee. So you're not giving up any control with this type of trust. What you also name is a successor trustee. The successor trustee acts just like a power of attorney. So when the grantor and trustee become incapacitated and can't manage the affairs anymore, that's when the successor trustee steps in. And when the successor trustee steps in, they're able to pay bills, they're able to access accounts, they're able to do everything that the person who created the trust can do. And then lastly, we have the beneficiaries of the trust. So usually the grantors, the trust makers, are going to be the beneficiaries of the trust until they pass away. And then that's where we name the people who are going to inherit from the trust. So talking about the revocable living trust in terms of incapacity planning, you can name the person to control your property after you become incapacitated or after you pass away. Again, that's the successor trustee. Another really nice thing about the revocable living trust is that you can leave a lot of detailed instructions in a trust about where you want things to go, how you want money used, how you want to be taken care of. So for example, I don't want to go into a nursing home, or I want to spend all of my money to stay in the home as long as possible, or I don't want to spend all of my money to stay in the home. I'd rather see that money go to my family and I'll go to a facility. So you can leave really detailed instructions about how you want your money used and spent. You can put all of those instructions in your trust for your successor trustee. Now, in order for the trust to work, it must be funded. So funding is the process of moving things into the name of the trust. The reason this is so important is because if you remember that chart from at the very beginning, it said, you know, if you own it in your own name, it goes to probate. If you own it with a joint owner, it goes to the joint owner. If you own it with a beneficiary, it goes to the beneficiary. The way for the trust to work and the trust instructions to work is if the trust owns it, the trust says where things go. So we take your accounts, we take your bank accounts and we retitle them in the name of the trust. We take your house and we do a new deed and we file it with the county so that in the county, it's on file as the trust owning it. So funding the trust is very important for your plan to work. So let's go through some of those estate planning goals and see if a trust might work for you. So I want to control my property while I'm alive and well. Yes, we haven't given any power away. We're the trustee. We haven't given anything away. I want to take care of myself and my loved ones if I become incapacitated. Yes, the trust names the successor trustee who can act when you become incapacitated. And you can also put in instructions of how you want your money spent if you're incapacitated. Number 3, I want to give what I have to whom I want, the way I want, and when I want. Yes, so in your trust, you leave instructions about where you want things to go after you pass away. And you can leave very detailed instructions. I mentioned this at the beginning. You can leave detailed instructions about, you know, I want my trust money to pay for college for my grandchildren. I want each of my grandchildren to get a car when they turn 16. You can leave very detailed instructions like that. Number 4, I want to maintain my privacy and avoid court control of my affairs. Yes. With a trust, everything is private, nothing goes through probate. So that's a big one. And then the last one, I want to save every tax dollar, professional fee, and court cost possible. That one's a maybe. So a trust is not the right option for everyone. There's no point in spending the time and money to set up a trust with all sorts of bells and whistles when you have one child and you are leaving everything to that one child outright for them to manage. So it really depends on your situation. A trust isn't going to be right for everyone, but it does make sense for a lot of people. Now, all along, I've been saying there are 2 times when you pay for your estate plan, when you set it up, and then when you go to implement it. So on the high end of costs, setting up a trust, or sorry, setting up an estate plan is going to be the trust. The trust is going to be the most expensive estate plan to set up at the beginning, but it is not the most expensive to implement after you pass away. So if you remember when we talked about probate, I said in the state of Wisconsin, a probate administration after you pass away is likely going to cost between 4 and 5% of the total estate. To compare that to a trust is usually only going to cost 1 to 2%. So you're paying at least half as much to do a trust administration than a probate administration. So you pay a little bit more on the front end to set it up, but at the back end, you're going to save more. And then it's the exact opposite for a will. You get a fairly inexpensive plan when you set up your will, but then when you have to go through probate, it's going to cost you quite a bit more. So I do like to address using trusts and the estate tax, because a lot of people say, well, I don't think I have enough money, I don't need a trust. We're not using trust to avoid estate tax. So right now, people are not paying estate tax unless they hit $12 million per person. So for married couples, that's 24 million. So unless you have that much money, you're not paying an estate tax. So that's not why we're using trust. Why use trust? A big one is probate avoidance. So you want to reduce the fees, you want it to go quicker, you want to stay out of probate court. A trust does that for you. The next reason to use a trust is that it counts as your incapacity plan. So again, we have that successor trustee where we can name the person who's going to manage our accounts if we become incapacitated. It provides asset protection for the surviving spouse and for the children. For the children can be a huge one for people. So if somebody comes in and they're worried, you know, they've got 3 daughter-in-laws and 2 of them are wonderful and one is a little iffy, and they say, you know, I love my daughter-in-laws, but I don't want to see them get half of my son's inheritance if they get divorced, or if my son passes away, I want to see it go to the grandkids. The asset protection that comes with a trust is one way to make sure that's going to happen, that nobody's going to get it in a divorce, nobody's going to get it in a bankruptcy. So there's a lot of asset protection that can be built in with a trust. Remarriage protection. Now this goes back to joint ownership, where if somebody gets remarried and we have a blended family, we might accidentally leave out half of the children, or maybe on purpose, depending on who passes away first. So with a trust, you can make sure that doesn't happen. You can say in the trust that, you know, even if I get remarried, everything's going to the kids, or if I get remarried, half goes to my spouse, half goes to the kids. So you get to say that in your trust. Another benefit of the trust is if anybody is receiving government benefits. So if somebody gets disability, somebody gets SSI, somebody gets Medicaid, somebody gets Badger Care, and the program won't allow them to inherit the money in their name, what we can do is we can have that individual inherit the money in a special needs trust, and that way their benefits from the government will be protected. And the last point up there says life estates. So what I mean by that is if we want to keep money in the bloodline. So this is very common. If your son passes away, you want to see it go to your grandkids. You don't want to see it go to the in-laws. You don't want to see it go to stepchildren, that sort of thing. With a trust, you can say what happens to the money when your son or daughter passes away. You can say, I want it to go to my grandkids. I want it to go to my great-grandkids. It can go on indefinitely until the money runs out. So all of that can be talked about and included in a trust. So trust is really a good way if you were, concerned by any of the other estate planning techniques, possibly losing it to remarriage or losing it to divorce or lawsuits, things like that. The trust is really the answer to protect from those things. And then this is just a little drawing about kind of how the trust works. So again, we have an example married couple here. It's William and Mary. They create a trust together. We call it a joint revocable living trust, and they put their house and their bank accounts and everything into the trust. When the first of them passes away, the survivor, Mary, gets to keep the money, gets to use the money. And then when both of them pass away is when it goes down to the children, and the children get that protection from divorce, from lawsuits, from bankruptcy. We say that when the children die, it goes to the grandchildren. So that's how we get all of that asset protection in a trust. And that is everything that I have to talk about. I'm going to stop sharing my screen now and see if we have any questions at all.
Okay.
See, I can check the chat here. It doesn't look like we have any in the chat. Did anybody have any questions? If you want to unmute yourself and ask right now, you can do that.
Hi, Stacy. This is Leslie.
Hi, Leslie.
I have a question regarding the life estate. My
Okay.
parents years ago set up a life estate for my brother and I.
Okay.
And my mother's passed away. My father's in assisted living. And I'm just curious, when you mentioned that it doesn't work anymore through Medicaid, does that mean only if you're using Medicaid to be able to pay the bills? Right now, we're in that percentage where we're paying the bills through whatever my dad's income is and also from our investments.
Okay.
Are we still okay as far as everything coming to us? And we've got a quit claim deed on the house that my dad still owns?
Yes, so if you're not on Medicaid, you're completely fine, nothing to worry about. And
Okay.
even if you get to the point where you need to be looking at Medicaid, you're fine depending on when the quitclaim deed was done. So the magic date for Medicaid is August 1st, 2014. If the paperwork was signed before August 1st, 2014, the house is protected.
Oh, good.
If the life estate was done after August 1st, 2014, the house would not be protected.
Okay, I think it was 2010.
Okay, so then, yep, you'd be protected. Now, Leslie, if you don't mind, I'm gonna use you as an example here. Leslie just told me that her dad is paying privately out of pocket for his long-term care because he is not yet eligible for Medicaid. For a single individual to be eligible for Medicaid, it's under $2,000 in countable assets. Something that I help people with is getting under that $2,000 limit without having to spend all of the money. So just to do a real quick example of how this might work, let's say dad has $200,000 in investments. And so he's way over the $2,000 limit. He's $198,000 over the limit. What I can help people do is take that $200,000 and half of it maybe is still going to go to the assisted living, but the other half of it, $100,000, could go to the family as a gift. And by doing that, we are making sure that some money goes to the family, that's the inheritance. And we make sure that we don't have to spend everything down to our last $2,000. So that is something that I help families with all of the time. If they don't have the 5 years to do the irrevocable trust, there are still ways that we can protect the money, and it works whether you have, $50,000 or $500,000. Generally speaking, we can take half of it and still protect it.
That's really helpful. Thank you so much.
So Leslie, if that sounds like something we need to do for your dad, just let me know.
Okay, and I'm in Minnesota.
Okay, so if you need a Minnesota attorney, I can set you up with some.
Okay, thank you.
Are there other questions?
Stacy, this is Mary, and I have a question concerning my thrift plan. Is there a benefit to listing the individual beneficiaries versus using the trust? I mean, I don't have children, I don't have a spouse, so it'd be going to nieces and nephews and such.
Yeah, so that's really, it's a personal decision. If you like the idea of asset protection for them is why you might do the trust in your situation. So again, some of those things that I mentioned, you're worried about divorce, you're worried about lawsuits. I would say, in my experience, when it comes to nieces and nephews, people aren't as concerned about that as they are with their own children and making sure that their children are making good decisions with their inheritance. But if those are some of the things that concern you, another reason, Mary, that you might list a trust instead of your nieces and nephews is depending on their age. So if your nieces and nephews are young, either under 18 or maybe under 21, just not really firmly in adulthood yet, you might consider listing a trust for them until they hit an age where you feel confident that they would make good decisions with that money.
Okay, thank you. And actually, they are all over 20, so we're good.
Okay.
Okay. Is it faster when I pass if it's listed as beneficiaries, and then they can just take my death certificate? Yep. Is that faster for them? And is there any tax advantage either way?
So
and I'm in Minnesota.
Okay. So the taxes are going to be the same either way, whether it's a trust or just a straight beneficiary, no difference in taxes. But as far as time and cost, listing them directly as beneficiaries is going to be quicker and less expensive than listing a trust.
Okay. Thank you.
All right. Yeah, no problem, Mary. Other questions? Hearing none. We are right at 7:30, so we're right on time. I'm going to let Carla jump on and finish us off here, but I do just want to say for anyone in the area, so I am in Milwaukee. We serve all of Southeast Wisconsin at our law firm. So if anyone heard anything tonight that kind of piqued your interest and thought, you know, I really should go and talk to Stacy, our office does offer complimentary consultations. So you have documents and you want me to look at them, or you've been thinking about doing documents but haven't gotten around to it yet. You can meet with me at no charge. I'd be happy to meet with you. And then for all of the people who are outside of Wisconsin or outside of Southeast Wisconsin, if you need to talk with an attorney, you can ask your financial advisor for a referral. If they don't have somebody local that they work with, I can put you in contact with someone local. And I thank you for your time tonight. And Carla, I'll let you finish off, okay?
Yes, very good. Thank you, Stacy, so much. We appreciate your expertise. And, you know, the information on the estate planning, the wills, the trust, the irrevocable trust, those are all common in all states. So this information, there's some specific state rules and regulations that we must follow, and that's why Stacy works out of Wisconsin. We would refer other attorneys. So if you are from a different state, please let us know and we'll get you a referral as well for a different state. So, but we appreciate it, Stacy, so much. You did an excellent job. Thank you for all your
Thank you.
expertise.
Thank you.
Thanks,
All right,
everyone.
well, thanks everyone, and everyone, I don't know, stay out of the snow, stay out of the ice.
Be safe.
All right, bye everyone.
Take care. Bye-bye.